The federal judiciary of the United States is one of the three branches of the federal government of the United States organized under the United States Constitution and laws of the federal government. Article 3 of the Constitution requires the establishment of a Supreme Court and permits the Congress to create other federal courts and place limitations on their jurisdiction. Article 3 Federal judges are appointed by the President with the consent of the Senate to serve until they resign, are impeached and convicted, retire, or die. All federal courts can be readily identified by the words, United States, in their official names. No state court may include this designation as part of its name. The federal courts are generally divided between trial courts which hear cases in the first instance, and appellate courts which review specific contested decisions made by lower courts. The United States District Courts are general federal trial courts, although in certain cases Congress has diverted original jurisdiction to specialized courts, such as the Court of International Trade, the Foreign Intelligence Surveillance Court, the Alien Terrorist Removal Court, or to Article 1 or Article 4 tribunals. The district courts usually have jurisdiction to hear appeals from such tribunals. The United States Courts of Appeals are the intermediate federal appellate courts. They operate under a system of mandatory review, which means they must hear all appeals of right from the lower courts. In some cases, Congress has diverted appellate jurisdiction to specialized courts, such as the Foreign Intelligence Surveillance Court of Review. The federal courts of appeals sit permanently in 13 appellate circuits. Note that there are several other federal courts that bear the phrase, Court of Appeals, in their names, but they are not Article 3 courts and are not considered to sit in appellate circuits. The Supreme Court of the United States is the court of last resort. It generally hears appeals from the courts of appeals, operating under discretionary review, which means that the Supreme Court can choose which cases to hear by granting writs of certiorari. There is therefore generally no basic right of appeal that extends automatically all the way to the Supreme Court. In a few situations it sits as a court of original jurisdiction. Besides these federal courts, described as Article 3 courts, there are other adjudicative bodies described as Article 1 or Article 4 courts in reference to the article of the Constitution from which the court's authority stems. There are a number of Article 1 courts with appellate jurisdiction over specific subject matter, including the Court of Appeals for Veterans Claims and the Court of Appeals for the Armed Forces, as well as Article 1 courts with appellate jurisdiction over specific geographic areas such as the District of Columbia Court of Appeals. The Article 1 courts with original jurisdiction over specific subject matter include the bankruptcy courts, the immigration courts, the Court of Federal Claims, and the tax court. Article 4 courts include the High Court of American Samoa and territorial courts such as the District Court for the Northern Mariana Islands, District Court of Guam, and District Court of the Virgin Islands. Federal judges, like Supreme Court justices, are appointed by the President with the consent of the Senate to serve until they resign, are impeached and convicted, retire, or die. In April 2013, about 10% of federal seats were vacant, with 85 of 856 positions unfilled and 4 vacancies on the prestigious Court of Appeals for the District of Columbia Circuit. The high vacancy rate has been attributed to politics, particularly Senate filibustering of potential appointees by senators. In many cases there is no nominee for the position. However, the Senate has a tradition of senatorial courtesy in which nominees are only considered if the home senators approve. In May 2013, Congressional Research Service published a paper analyzing the vacancies and appointment process. Under Article 1 of the Federal Constitution, Congress also has the power to establish other tribunals, which are usually quite specialized, within the executive branch to assist the President in the execution of his or her powers. Judges who staff them normally serve terms of fixed duration, as do magistrate judges who assist Article 3 judges. Judges in Article 1 tribunals attached to executive branch agencies are referred to as administrative law judges and are generally considered to be part of the executive branch even though they exercise quasi-judicial powers. With limited exceptions, they cannot render final judgments in cases involving life, liberty, and private property rights, but may make preliminary rulings subject to review by an Article 3 judge. The Supreme Court has interpreted the Constitution as placing some additional restrictions on the federal courts. For example, the dock